Hello, my friends. It is so good to be back here with you on our lives. I am very, very excited to be here with you again on our daily live streams. As you know, here on Sped Up News, we do go live every single day, and we are bringing you the top news stories. I've been covering Tom Sandoval and his very interesting positions that he's been taking in the media right now about reality TV pay. I have been covering Lala Kent's trademark infringement lawsuit over the Give Them Lala brand mark. I have also been covering a lot about the Sean Diddy Combs prosecution, and as well as the civil suits that are just coming out of the woodworks against Diddy. And I am here with a very interesting story tonight. President-elect Donald Trump believes that he is immune from prosecution and enjoys presidential immunity right now, even as the president-elect. So Trump is claiming that he cannot be prosecuted, even now, even though he has not yet been inaugurated as president again. That will not occur until January 20th of 2025. He's nonetheless saying that he enjoys presidential immunity right now. So let's pull up the story here. As reported in Yahoo News, the insider reports that Trump argues he has presidential immunity now as president-elect. Now, Trump hopes to make his one criminal conviction disappear prior to his January 20th inauguration. In a filing that he made public on Tuesday, he says he's immune from prosecution even now as president-elect. So let's take a note here. Trump's attorneys are hard at work. They must be very hard at work because they have filed a 72-page motion in court on Tuesday alleging that Trump has presidential immunity right now and that he is immune from prosecution. So back to the story here, we see that sentencing in the New York hush money case has been indefinitely delayed by Trump's latest dismissal bid. Trump is essentially arguing that his case, that his conviction should be invalidated. So Donald Trump then, this article goes on to state that the United States Supreme Court found in July that presidents enjoy broad immunity from prosecution. The question here is a president-elect also immune? So that's the big question that has not necessarily been squarely addressed. And Trump is raising this right now. He is arguing that he is immune from criminal prosecution, from suit, that he enjoys presidential immunity right now, even though he's not president yet. So moving forward in this article, the big question in everyone's mind is a president-elect also immune? In a 72-page filing made public Tuesday, lawyers for Donald Trump argue just that. They argue that he's immune from prosecution right now. And so his hush money conviction should be immediately dismissed, according to them, and his 34 felony convictions wiped clean, they argue. Quote, following Donald Trump's overwhelming victory in his 2024 presidential election, presidential immunity is an unavoidable legal impediment to further proceedings in this case, end quote, his lawyers argue. The massive motion to dismiss mixes old grievances against New York prosecutors and the trial judge. All are portrayed as politically motivated, with citations from case law and federal policies spanning from the 19th century to just last month. The filing cites the U.S. Supreme Court's July 1st landmark presidential immunity decision, which extends broad protections from prosecution to sitting presidents. Presidents-elect, during their brief but crucial transition to the office, warrant the same protections, Trump's lawyers argue. The filing also cites special counsel Jack Smith's decision barely a week ago to drop Trump's 2 federal indictments. That decision was premised on long-standing Department of Justice policy barring the prosecution of sitting presidents, Trump's lawyers noted. In moving to scuttle the two federal cases, the Department of Justice found that this ban on prosecuting sitting presidents also applies to presidents-elect, Trump's lawyers argue. So let's unpack this, because this is actually a really important, crucial concept here. So President-elect Trump's lawyers are saying, hey, look, we have a very, very recent U.S. Supreme Court July 1, 2024 decision. This was considered to be a landmark decision that said that sitting presidents enjoy this broad immunity. So this filing on July 1, landmark presidential immunity decision, extends broad protections from prosecution to sitting presidents. And Trump is arguing that by extension, the president-elect himself should also be immune. So let's actually take a look at this decision by the United States Supreme Court. So we need to unpack this, because this is the major decision, the most recent, most persuasive decision that President Trump is seeking to rely on to say that he should not be prosecuted and that they can't touch me. I'm immune from prosecution. I am president-elect. That is his position. And that is the position that his attorneys are taking very, very strongly. Imagine the cost involved in filing a 72-page motion to dismiss. Well, that is exactly what Donald Trump's attorneys have done here. So when we look at this case, let's go out, first of all, let's go out to this case here. And we're going to look at, I'm going to share my screen with you. And I'm going to talk to you about this case, this United States Supreme Court case that was from July 1st, 2024. So essentially, what the Supreme Court had ruled was that the sitting president enjoys broad prosecutorial immunity. So it's noted that Trump's lawyers, Todd Blanche and Anil Bove, are asking the trial judge, New York Supreme Court Justice Juan Merchan, to immediately dismiss the hush money indictment. Trump was convicted 6 months ago on 34 counts of falsifying business records. Jurors found that he made false entries in Trump Organization records throughout his first year in office in order to retroactively hide a hush money payment that silenced porn actress Stormy Daniels 11 days before the 2016 election. So, friends, these are the allegations. These are allegations. They have been published. This is what they're alleging. They are alleging, once again, Trump's two attorneys, Todd Blanche and Anil Bove, are saying that the New York judge, New York Supreme Court Justice Juan Merchan, should immediately dismiss Trump's hush money indictment. Trump was convicted 6 months ago on 34 counts of falsifying business records. Jurors found that he made false entries in Trump Organization records throughout his first year in office in order to retroactively hide a hush money payment that silenced porn actress Stormy Daniels 11 days before the 2016 election. So those are the allegations against Trump. And he did receive an indictment, and now his lawyers are saying, well, he's president-elect, so he should be immune from prosecution. They're alleging that this hush money indictment should be tossed out. So moving back to the article that was reported by Insider, Yahoo News, Manhattan District Attorney Alvin Bragg framed the case as a conspiracy to interfere with the election. Trump was convicted after a 5-week trial and 10 hours of jury deliberation over 2 days. Bragg has promised to fight the claim that such a thing as presidential-elect immunity even exists. So that's interesting. So Manhattan District Attorney Alvin Bragg has promised to fight the claim that such a thing as presidential-elect immunity even exists. So he's saying no, he's calling BS and saying Trump's attorneys, I don't care about this 72-page motion to dismiss that you have just filed, arguing that Donald Trump, as president-elect, should be immune from prosecution, even before he takes office on January 20th. That's what the Manhattan District Attorney is saying. He's saying, I don't care what you filed. I don't care what Trump's attorneys are doing. I don't care how much they're getting paid to file these 72-page long filings. He is saying, I am going to fight this fight, and I am going to fight against Trump's argument that he is immune from prosecution. This is big news, friends, because this has landmark presidential impact. This court's decision in Donald Trump's case is going to determine future events, because Trump is saying, hey, look, we've got United States Supreme Court precedent, their July 1 landmark decision, where they said that the sitting president enjoys broad prosecutorial immunity. And he is saying that that same logic should extend to the president-elect. So let's move back to this article here, friends. So only after the judge, okay, so we quote, so this is Manhattan District Attorney Alvin Bragg. He says, quote, we believe these arguments are incorrect. Bragg wrote this in response to a November 19th defense letter. Bragg's letter promises to counter Trump's latest bid to dismiss the case. Prosecutors are due to file a response brief by Monday, December 9th. Only after the judge decides if the case is dismissed can Trump's sentencing, that's already been postponed 3 times, be calendared or canceled. And even if Marchand, the judge, calendars it, Trump's lawyers have promised to halt the sentencing by immediately appealing his decision through the federal court system to the Supreme Court of the United States if necessary. So that is insane, friends. That is absolutely very interesting strategically. So Trump's sentencing has already been postponed several times, 3 different times. And his lawyers are saying that, hey, even if Juan Marchand, the judge, goes ahead and calendars his sentencing, we are going to file an immediate appeal and take this appeal through the federal court system, even if we have to go all the way up to the United States Supreme Court, the Supreme Court of the United States. We are going to take the appeal, and we are going to allege and argue and claim that Trump is immune, that he enjoys immunity from this prosecution. So this is a very, very important case to watch, friends. This has a lot of implications. So the next part of the article states, the argument that a president-elect has immunity is a very interesting item. Why does Trump believe he enjoys presidential immunity from prosecution even now as president-elect before he's even been elected president? Well, his 2 attorneys, Blanche and Bove, argue that there is little material difference between President Trump's current status after his victory in the national election and that of a sitting president following inauguration. And in a way, that does make sense because, his attorneys are saying, hey, look, Trump is facing many of the same considerations, many of the same issues that he has to be mindful of as a sitting president. There's a very small amount of time between now and January 20th, 2025, when he's going to be inaugurated as president. So they're saying, hey, look, the same considerations that the Supreme Court took into account in making their landmark January 1 decision, holding that sitting presidents enjoy broad presidential immunity against prosecution, his lawyers are saying that same logic should apply to Donald Trump even before he takes office. So next, a second argument for special treatment of presidents-elect made repeatedly by the 2 lawyers in the past month draws on the Presidential Transition Act of 1963, which provides for the orderly transfer of executive powers. Quote, the Presidential Transition Act of 1963 was passed to promote the orderly transfer of the executive power in connection with the expiration of the term of office of a president and the inauguration of a new president. Trump's lawyers write now, quoting from the act. The act requires, quote, all officers of the government, end quote, to, quote, take appropriate lawful steps to avoid or minimize disruptions that might be occasioned by the transfer of the executive power, end quote, they argue. The brief also cites the Constitution's Supremacy Clause, which holds federal law as taking precedence over state law. Here, Trump's attorneys, Blanche and Bove, paged through 2 centuries of case law, quoting, among other citations, an 1819 court ruling that found states, quote, have no power to, quote, retard, impede, burden, or in any manner control, end quote, the president or other federal authorities. Quote, President Trump's status as president-elect and the soon-to-be sitting president is a legal impediment to further criminal proceedings based on the presidential immunity doctrine and the Supremacy Clause, end quote, they write. So this is really important. So his lawyers are really digging deep. Trump's lawyers are really digging deep. They're going back to a case from 1819. That's a long time ago, friends. And they're citing cases from all the way from 1819 up through the July 1st, 2024 decision of the United States Supreme Court, which holds that sitting presidents who have taken office enjoy broad immunity against being prosecuted. So President Trump's attorneys are hard at work. Let's just put it that way. They've had many a night in front of the burning the midnight oil to make this case for him, filing the 72-page motion to dismiss for him. So again, President Trump's attorneys are saying we have lots of precedent here. We have a lot of authority. They're saying the state courts do not have power. Federal law is supreme. There's a supremacy clause in the Constitution that when state law and federal law are on the same topic, the federal law is supreme, state law is superseded by the federal law, right? We have many concepts in the law that reiterate that, such as federal preemption, right? So his attorneys are saying that if we were to allow President Trump to be prosecuted in this period of time where he is, or sentenced during this period of time when he is about to become the president, right, on January 20th, 2025, they're alleging it would cause a great disruption in the transition of executive power. When one president goes out, Trump's coming in. They're saying Donald Trump has many of the same considerations that a sitting president has, and that therefore he should enjoy that same immunity from prosecution and sentencing that a sitting president would. So friends, let's go back to this article because this is very informative. A so-called interest of justice dismissal would require the judge, Juan Marchand, to find, quote, some compelling factor, consideration, or circumstance under which continuing a prosecution would constitute or result in injustice, as the act itself declares. In considering the interest of justice, the judge, Juan Marchand, must weigh the strength and seriousness of the offense, the extent of the harm it caused, and the, quote, history, character, and condition of the defendant. So basically, he must consider the history, character, and the condition of Donald Trump. The judge must also weigh the impact of a dismissal upon the confidence of the public in the criminal justice system. Blanche and Bove did not immediately respond to a request for comment on this story. A spokesperson for the Manhattan DA's office also did not immediately respond to a request for comment. So again, friends, this is going to be an incredibly important story to watch. So let's stay tuned. I will continue to report this here on Sped Up News. We go live every day, friends. to give you live news updates. We've been covering the P. Diddy story at nausea. We've been covering Vanderpump Rules, Lala Kent's trademark litigation involving Give Them Lala brand. We have been covering Tom Sandoval and the most recent positions he's taken in the news on residual payments for reality TV actors. So hit the subscribe button if you'd like to support our channel and be kept up to date every day with live news updates in the entertainment and celebrity news realm. Thank you guys so much for joining the live, and I look forward to seeing you on our live tomorrow. Bye, friends. Good night.